Thanks, Christina and Farouk, and thank you everyone for attending today. I hope you find the session useful. As Christina is saying, we're going to talk about the EU settlement scheme, how it applies to students. We are covering individuals who were already in the UK by the end of 2020, and we will also touch upon family members joining at a later date after the 31st of December 2020. But we'll make a start with the presentation. If anybody has any questions, there will be a period at the end of the session to be able to unmute yourself and ask questions, or to pop them in the chat or Q&A box, whichever you feel best doing. Right, so the EU settlement scheme. This is a list of what we'll be covering today. So who can apply, the different statuses, the deadline dates, application process, a little bit about individuals who are under the age of 21, family members, and we'll touch on a little bit about the position of EU citizens now that the UK has left the European Union and the transition period has ended, and also a very little bit about British citizenship. But the main focus of this session is about the EU settlement scheme, people's eligibility for it, and how to apply and to get a status. So what is the EU settlement scheme? Just as a little recap here, because I'm sure many of you already know this, but as a result of the UK leaving the European Union, the UK government has implemented a system whereby EU citizens who have been living, working, studying in the UK already under freedom of movement can gain an immigration status that protects their rights to continue living, working, studying in the UK. Now that we have left the European Union. So this is why the European Union settlement scheme was set up. We'll talk a little bit about this, the application process and the successful applications, and what those status outcomes means for that holder, and what that holder can expect to gain from those statuses moving forward away from now that we've left the EU. So who can apply? It's open to individuals from the EU, the EEA, and Swiss citizens. It's also open to their family members. It relies on the EU citizens and their pre-existing family members already living in the UK by the 31st of December 2020. Irish citizens, although Ireland is clearly part of the European Union, the UK and Ireland has a separate arrangement called the Common Travel Area, which means that Irish citizens and UK citizens can move freely between the two countries without the need for any kind of restriction or visa restriction. It precedes the European Union and freedom of movement, and is completely separate from it. And as a result, it means that Irish citizens don't actually need to apply to the EU settlement scheme. They can do if they wish, but they don't have to. But it is worth pointing out that their non-European family members, if they are living with them in the UK or coming to join the Irish citizen in the UK, then they do need to apply to the EU settlement scheme, which is why it's still partially relevant to Irish citizens, even though they themselves don't need to apply. It is also open to family members who are joining an EU citizen, so an EU citizen family member who was living in the UK by the 31st of December. So there will be some people who can still come to the UK as a joining family member, even though they themselves weren't living in the UK by the 31st of December. But we'll go on to talk a little bit more about that in a future slide. Some key dates. So the UK left the Union on the 31st of January 2020 and then entered into a period called the transition period, which ran for the rest of 2020 until the 31st of December. The scheme application is relevant in terms of these dates because it requires most EU settlement scheme applicants to have been living in the UK by the 31st of December, with the exception of those family members who can join later. But for the majority of people, that date, the 31st of December 2020, is the key date by which they must have been living in the UK in order to be eligible for the scheme. And then deadline for the scheme, to apply to the scheme, is going to be the 30th of June 2021. So not that long now, just under 3 months to get the applications in. So an application is submitted, and we'll talk about the process in just a second, but what the individual applicant is applying for is one of two statuses. So settled status is awarded to those individuals who've been living continuously in the UK for a period of at least 5 years or more. You might also hear settled status referred to as something called indefinite leave to remain. And having indefinite leave to remain or settled status means that there is no restrictions on that person, on that holder, in terms of how long they can stay, what they can do in terms of work or study, and they can access most social security benefits as well. A settled status holder, again, implied in the name with indefinite leave to remain, it's a secure status that doesn't expire, doesn't have any expiry date. You can stay in the UK for as long as you like. The only slight word of warning is that people who hold settled status, if their circumstances change and it takes them outside the UK for an extended period of time, they do need to be aware that an absence from the UK of more than 5 years will result in them losing that settled status. The idea being that settled status, the indefinite leave to remain, is designed as a permit to allow people to stay on and live as their main point of residence in the UK. So it's felt by the Home Office, by the UK government, that if someone leaves for more than 5 years, then they are not really living in the UK any longer, and then therefore they lose their status. That said, somebody could come back to the UK, spend quite a very short period of time, and then go again, and you would reset the clock at 5 years. So it does give you that ability to have your plans might change. You might go back to your home country, or back to a different country entirely and be outside the UK, but there is a bit of flexibility there with settled status. Not so much with pre-settled status. So pre-settled status is a temporary leave designed to enable people to stay on in the UK in order to accumulate the 5 years of continuous residency that will then make them eligible for the full settled status. So pre-settled status is awarded to people who apply to the EU settlement scheme and who have not yet been living in the UK for 5 years. The pre-settled status itself is also referred to as limited leave to remain. Limited meaning that there is a time limit associated with it, and that time limit is 5 years. The 5 years starts from the date that pre-settled status is awarded, and it will run for that 5 years. During that time, the holder has the ability to continue working, studying, accessing the NHS, some social security and benefits, subject to eligibility criteria. But the main idea intended with this status is to accumulate your 5 years in order to reapply and upgrade from pre-settled to settled status. Holders of pre-settled status can do that at any time during the 5-year validity of the pre-settled status. They don't have to wait until close to the end of it. In fact, we would recommend that as soon as somebody reaches the anniversary of them having been in the UK for 5 years, that they reapply as soon as possible to get the settled status. But one thing is for sure is that once that pre-settled status has expired, the ability to upgrade from pre-settled to settled has gone. So it's really important that people make a note of how long their pre-settled status is valid for, and make sure that they do make another application to upgrade within that 5-year time frame. You might see on some information or government websites that says that pre-settled status holders can leave the UK for up to 2 years and still retain their pre-settled status. This is correct. However, it's a bit misleading, because anybody who is outside the UK holding pre-settled status for more than the acceptable periods of absences, which again I will come on to in just the next slide or two, but generally speaking, being outside the UK for more than 6 months will break a person's continuous qualifying period or continuity of UK residence, and will make them ineligible for future settled status, which is problematic if people do want to stay on in the UK, because if their continuity of residence is broken and they are no longer eligible for future settled status, they will have to find another way in which to stay on in the UK under a different immigration route. So it's really important, if you hold pre-settled status or you're only eligible for pre-settled at this particular point in time, that you are mindful of the time that you spend outside the UK. This has been complicated by COVID, and there are some concessions for students who have been studying remotely. Again, we'll come on to that in a bit more detail in a moment, but it's just something to bear in mind that pre-settled status, you do need to be very careful about how long you're spending outside the UK. And then our last point there is just to reiterate that pre-settled needs to be converted within the 5-year validity before it expires. The process is a digital process, entirely digital for most people. There are some exceptions where some different types of applicants apply using a paper form. Those paper form applicants might be those who don't have a valid ID document, so their passport might have expired or they never had a passport. Hopefully that's not the case for anyone attending here today, but if it is relevant, an expired or no or missing ID document, passport or national ID, does not stop you from making an application. You just have to go through a slightly different application process. But all applications have in common that you have to show your evidence of your nationality and your ID, followed by UK residence. And if you're a family member with an EU citizen living in the UK, then you have to show your relationship to that EU citizen. The digital process involves for the most part, for people with a biometric passport or national ID card, a process by which you scan the information held within the biometric chip within that document and complete a straightforward online application, filling in your name, your details, your contact details, how long you've been in the UK, a national insurance number. A national insurance number is asked for in the application, but if the applicant doesn't have a national insurance number, it's not the end of the world. They just say, no, I don't have a national insurance number, and then they will be asked for different documents at the end of the application to prove that they've been living in the UK. The purpose of the national insurance number is to enable the Home Office to do a check against the tax records to see whether that person's been working, and therefore by default they are living in the UK. But like I said, if you don't have a national insurance number, it's no barrier to application. There are other ways in which you can prove your UK residency. All applications are checked against criminal record databases, both UK criminal record databases and some overseas ones, particularly where police database records are shared between EU countries. And after the application process, once a status has been granted, that status is awarded to that applicant via an online profile. So most people, with the exception of some non-EU family members, don't get any kind of hard copy document to show their status. Everything is lodged online on a digital profile portal that the applicant relogs into every time they want to see their status or to share their status with a third party. The application is completely free of charge, doesn't cost anything. And as I said, the scheme is open until the end of June. So applications are there open and ready for people to apply free of charge until that point. So now we're talking a little bit about the evidence of UK residency. So the way that that is done is initially via a national insurance number, but if somebody doesn't have a national insurance number, or it's also the case sometimes that people have incomplete national insurance number records, whereby they might have worked for 2 months, had a break, gone back to work, or claimed benefits for a period of time, or if a student might not have never worked at all, might have a national insurance number but has never worked, has never used that national insurance number in a social security application or in a work type environment, in which case that person won't have much of a record with national insurance or the tax office. So again, not a problem. There are other ways of evidencing UK residency. The first ones there listed are connected with work, so possibly not of such great need if that person has a national insurance number, but can be useful to fill in gaps if the national insurance record is a bit gappy. So pay slips, your P60s and P45s, and any kind of contract or letter from your employer. Probably most useful for students is an enrolment letter from the university confirming how long you have been studying at that particular university. You can also submit degree certificates and transcripts. Transcripts are quite useful because they show the duration of the qualification. Certificates, possibly not the duration. So make sure you use those if you're trying to show that you've been at a UK university for a particular period of time. Bank statements are another good one. Bank statements do need to contain your name and your UK address. It's also useful if they have a reasonable number of transactions on them. If you were to use a savings account, for instance, which doesn't have many transactions appearing on it, or you're not really spending very much on that savings account, you're only depositing money, then sometimes it's not clear enough that money is going in and out whilst the person is in the UK. So try and use a current account if possible, showing lots of transactions at all the usual places, you know, appear on your statement that say you've been at Tesco's or you've shopped at a particular shop. That's really useful for evidencing your presence in the UK. Utility bills, GP registration, council tax, all these things as well are useful, as are tenancy agreements and any evidence that you've been paying rent. Boarding passes and travel booking are useful for anybody who arrived close to the 31st of December, which was the cut-off date for arrival, and can be used as a evidence that that person was resident in December, the month of December. So it is useful for pre-settled status applications. Documents should have the applicant's name and their UK address on them. UK residency and absences. This is a really complicated area and is not something that has been made very clear by the Home Office or any of their guidance on the EU settlement scheme. Both statuses, both pre-settled status and settled status, are based around the person being physically present in the UK. And then the continuous qualifying period of residence, it might start from the day they first come to the UK, but it could start after that if that person has been here for many, many years, for instance. If someone's been here for many, many years, they can choose the 5-year period that they want to use as evidence that they have reached that settled status eligibility criteria. But for most people, it probably will be somewhere around the time that they first came to the UK. The continuous qualifying period must start must have started by the 31st of December. And then during the 5-year continuous qualifying period, on the person's journey to a settled status, that person cannot have been absent from the UK for more than 6 months in any 12-month period. The exception to that is that there can be one single absence of up to 12 months at any point during that 5-year qualifying period. And if it relates to study an overseas job posting, serious illness that took the person back home, or pregnancy and absences relating to pregnancy and childbirth, then those will be accepted and continuity of residence won't be broken. However, it is important to submit evidence of those things. So, for example, a student who spends an academic year or a calendar year in a different country, or has gone on a work placement in a different country, would need something from their university confirming that, and they would upload that with their application to show that they have had a permitted absence that doesn't break continuous residency. And with COVID, students have been given the permission by the Home Office to be outside the UK for up to 12 months if they are studying remotely. For EU students, it does rely on them having started their period of residency before the 31st of December 2020, but it does allow people who've been studying remotely or via blended learning to have spent periods of time outside the UK that exceed the usual 6 months. What that does mean, though, is that once the student comes back from that 12 months, and also important, it cannot be more than 12 months, any more than 12 months. At the moment, they are standing fast on this, and they're saying that 12 months, over 12 months will break the continuity of residence, and that person will no longer be eligible for the settlement scheme. If they already hold pre-settled status, they can keep that pre-settled status, but it's unlikely they will be able to convert it into settled status at a later date. What that means after coming back from your single 12-month absence is that you have to be very careful about absences that follow on from that. It's not clear in the guidance how they will calculate further absences in that 12-month period, because it's quite feasible that somebody might come back for 2 or 3 months and then go back home again for a period of time, and how that impacts on that person and their eligibility for future settled status is not 100% clear. And we get lots of inquiries from people asking about absences. Well, if I do this, can I do that? And really, it's just not always possible to advise on those types of individual scenarios. And our advice to students really is to keep your absences from the UK to an absolute minimum if you are hoping to get settled status in the future, because it's not yet been tested by that many people, given that COVID is such a recent thing, as to how the Home Office will treat multiple absences after somebody having been outside the UK for 12 months because of distance learning or remote learning. So it's important to just note your absences and try and keep them to a minimum where possible, and absolutely don't go beyond a single absence of 12 months. There's loads of self-help material for submitting an EU settlement scheme application, and for the vast majority of people, particularly students, you'll be used to using smartphones and laptops, hopefully. This will mean that the application process is pretty straightforward for you. But there are some really useful tools out there, one of which is a video walkthrough of the application process and how to use the document ID scanning app that's been produced by an organisation called Free Movement, and there are 2 links there for you to watch the relevant video, depending on whether you're an applicant or a child applicant. There's also a really detailed guidance document from an organisation called We Are Digital, That takes the applicant literally page by page through the application process, covering all different avenues depending on how you answer the questions. So it is quite a long document, but it's really, really comprehensive and really easy to follow. So that's a good one to have a look at as well. And we do have lots of information on our Newfields website as well. I should have mentioned at the start, the slides will be shared, so you will have copies of these links if you need them. Just a tiny bit about people who already hold some sort of immigration document. So European citizens haven't needed to apply for an immigration document for a very long time, but there was an option to do so if they wanted to. And some people who accumulated 5 years of living in the UK long ago might have applied for something called a permanent residence card, and that will have been issued under European Union law by the UK government, and as evidence that that person had lived for 5 years and had acquired permanent residence in the UK. So people holding those cards must still apply to the EU settlement scheme. Because that permanent residence card was issued under European law, that will become redundant and obsolete as of the 30th of June, or just after the 30th of June. So it is important to convert that document into an EUSS document. The application process is pretty much the same. It's more straightforward because your permanent residence card that they applied for maybe several years ago will have evidenced the fact that that person was living in the UK, and it will have evidenced their nationality identity as well. So it is a more straightforward process, but it must be converted into the up-to-date EUSS version. People holding indefinite leave to remain, this is only really applicable to people who've been in the UK for probably more than 20 or 30 years. People with a stamp inside their passport that says they have indefinite leave to remain. Strictly speaking, they don't need to apply to the settlement scheme, but we do advise that people holding old style documents do apply because it brings us to 2021 sort of documentation standards, and it will also give that person extended family reunion rights and also the ability to be outside the UK for longer. Under the old style indefinite leave to remain, absences were only limited to 2 years, whereas under the settled EU settlement scheme, somebody with settled status, which is the equivalent, the modern day equivalent, allows that person to be outside the UK for up to 5 years, so it's much more generous. Applicants under 21, so this might be relevant to students dependent on age, but applicants who are under 21 have the ability to apply either in their own parent, generally speaking, but also possibly a grandparent who is also living in the UK. So if a student came to the UK independently, has no other family here, then they would just apply in their own right. Age is not a barrier to applying in your own right. It's just that individuals who are under 21 have the option of either doing so based on their own UK residency or connected to that of their parent. And there are advantages to doing that. If the student has been living in the UK for a long time, or their parents have been living in the UK for a long time, but they haven't, they joined later for whatever reason, then by linking to the parent, it does mean that the child, i.e. somebody under the age of 21, can benefit from obtaining the same status as their parent, even if they themselves hasn't been living in the UK for 5 years. So it's just something to bear in mind. It may not be relevant to anyone here, so I'm not going to go into too much detail about it, but the information here is on that slide. But it is important to note that just because somebody is under 21, it doesn't mean that they automatically gain a status because of their parents. This would also extend to children born to students, so babies born in the UK or indeed outside the UK. But just because the parent has a status doesn't mean that the child automatically assumes the same status. They do have to go through an application process in order to obtain it. Family members. Since the 1st of January this year, there have been two different categories of family members. Both family members types rely on having a sponsor who is either eligible for a status or who's already got a status in the UK. And I'm going to speak from the perspective of being the family member of an EU citizen who was themselves living in the UK by the 31st of December. And when we talk about joining family members, it'll be about people coming from overseas to join that EU citizen who is already in the UK. If we look at the two different types of category, we've got family members and joining family members. Family members are generally non-EU citizens, and they are family members who were already living in the UK by the 31st of December 2020. They extend to close family members, so the spouse, civil partner, grandparents or parents, and children and grandchildren, but also incorporates extended family members, including unmarried partners who had a European document that proved their extended family relationship. In the case of unmarried partners, which tends to be the most common relationship that we encounter with students, what this means is that unmarried partners who were living in the UK as such by the 31st of December would have had to have had a document already under the European regulations, a biometric card, proving their relationship. Some extended family members didn't have that, and there might be different avenues then by which that person would apply, either as a family member in the UK under a different type of immigration category, so for instance under a student visa, or they might have to exit the UK and apply for a permit to come back in. Joining family members now include non-EU and EU citizens who have not lived in the UK before the 31st of December 2020. So they're coming to the UK for the first time on or after January 1st. And they are coming to join their EU sponsor, generally speaking, who was living in the UK by the 31st of December. The relationship must have existed before the end of the transition period on the 31st of December. So the relationship can't have commenced now since the 1st of January. It had to be in existence before then. And the exception to that, though, is newborn children. So don't expect the newborn child to have had a relationship with its parents if it was only born after the 31st of December. But that said, newborn children do come into the category of joining family members because they simply haven't been living in the UK before the 1st of January. Close family members are the only family members able to join an EU citizen already living in the UK. Unmarried partners can still apply under the European Family Permit application route until the end of June, and that's the way in which they would come to the UK for the first time with a permit, and then join their family member who was already here. How do family members and joining family members apply? The family members, remember, those that were already living in the UK by the end of December, and they apply much in the same way as their EU sponsor. They would just have to show their relationship to that EU sponsor in the form of either a marriage or birth certificate. They would need a biometric document, such as their passport or a biometric card, and they would need to show evidence of their UK residency that showed they were living in the UK. That's not correct, that date. It should be the 31st of December. So UK residency by no later than the 31st of December 2020. I will change that before we circulate the slides. Joining family members must apply from outside the UK unless they have, for instance, another type of visa that allows them to be in the UK already, such as a student visa. But for the most part, we're looking at joining family members from a perspective of people coming in for the first time. They incorporate both EU and non-EU citizens now. And an EU citizen would be able to apply directly to the EU settlement scheme using a biometric passport or ID document. A non-EU family member or an EU joining family member who didn't have a biometric passport or ID document, or perhaps their biometric chip inside their passport no longer works, it's damaged and doesn't scan, would generally apply for an EU settlement scheme family permit, which would mean going to a visa application centre, submitting a document and getting a printed permit to be able to enter the UK. And then upon entering the UK, would apply to the EU settlement scheme within 3 months. Important to know that joining family members can't apply from inside the UK if they entered the UK as a visitor. And it is worth noting as well that any EU citizen entering the UK for the first time on or after the 1st of January this year is indeed entering as a visitor under the UK immigration rules and no longer under freedom of movement rules, because they ended on the 31st of December. Just a quick note to say that there are some other citizens who are eligible for the scheme who are very specific circumstances, but non-EU spouses who have since divorced their EU partners can apply, as can applicants whose EU partner died, and there are some special arrangements for carers of British or EU children and adults. Potential issues that we found when advising students, those who arrived close to the deadline on the 31st of December, it is really important to keep evidence of your inbound transportation or flight tickets, boarding pass, to show that you were a resident in the UK by the deadline. We've talked a bit about absences from the as a result of COVID, what that means, how it impacts students' future ability to apply for settled status if they're transferring from pre-settled to settled. Home Office guidance does sort of change periodically, but it's not terribly clear. So it's worth, I will embed the link into here actually, so that you've got it after this session, but it's worth keeping on checking those guidance documents to see if there's any changes in the future. Those holding pre-settled status or who are only eligible for pre-settled status at this point in time must be really careful not to break their continuous qualifying period if they do want to eventually get settled status. We see lots of problems with either no national insurance records or incomplete national insurance records. Try not to worry too much about this. It's really common. And there is the ability to upload the additional residency documents, such as your utility bills, your letters from students from the university confirming your enrolment, etc. If an applicant is applying to the scheme and they believe that they are eligible for settled status, i.e. they've lived in the UK for 5 years or more, but the outcome of the application, the Home Office only offer them pre-settled status, the advice that we would give you is don't accept that. Find out if there are other evidence, residency evidence that you can submit to support your claim to settled status. Settled status is always the one you want to get because it's more secure, it gives you more flexibility to leave the UK, and you can pretty much forget about settled status once you have it. You don't have to think about this 5-year limit and you must apply again by the end of that 5 years. No, settled status you can relax a bit more in that you don't really have to do anything else once you've got that. So it's really worth holding out for settled status if you're eligible for it, but for whatever reason, the Home Office haven't been able to verify your continuous residence for 5 years. Think about other documents you could submit. The way that we would recommend doing that at the moment, whilst the scheme remains open and it's free of charge to apply, simply apply again with your new evidence. Or if the Home Office contact you, which they can do from time to time, once an application's been submitted, if the Home Office want more information from you, they will email you. So make sure you always check your inbox, including your junk mail, to see if there's got any communications in there. But they will invite people to supply additional information if they think that they're about to award you pre-settled status, but you've claimed settled status. So do keep an eye out for that. After the 30th of June, if somebody has applied but not had an outcome to their application, or if they missed the deadline altogether, and they are offered pre-settled instead of settled, then the way to challenge that would be to submit something called an admin review or an appeal. There will be information about that in the letter that you receive confirming what status you've been given. So don't worry too much about that at the moment, but there are ways to challenge a decision now and in the future. So don't necessarily think, oh, if it offered me pre-settled status, that's all I'm entitled to, and give up. It's worth persevering. In the very unlikely event that anyone is refused, please do seek advice. A tiny bit here about what this means now for EU citizens coming to the UK for the first time since January, is that freedom of movement has ended. So unless you're a joining family member, that EU citizen would be coming to the UK under the UK immigration rules, and UK immigration rules generally assign different types of visa for different types of situation. For example, a skilled worker visa, a student visa, maybe you're married to a British citizen, or a European settled person, a marriage visa, for instance. The UK immigration policies have had a bit of an overhaul, and they are being amended. It is now arguably easier to get a skilled worker visa than it was before. They have opened up the number of jobs that are available, and they've made different allowances for different salary rates. Anyway, generally speaking, these are the types of applications that EU citizens are going to have to make if they're not eligible, either in their own right to make an application to the EU settlement scheme, or if they're a joining family member. Here is a little slide about British citizenship, and the only reason we include this, the session is not really based on British citizenship, so I won't be taking any questions. But it is a natural question for people who are maybe potentially looking to make the UK their long-term home, or maybe they have children who've been born here that are British and they want to have the same nationality. But it's a personal choice, and people have lots of different reasons for becoming a British citizen or for choosing not to become a British citizen. I include this slide here because this infographic, again from that organisation called Free Movement, who did the application step-by-step videos for the settlement scheme, it just gives a little general overview about the routes to settlement for different people and their different circumstances. If we consider people who have settled status, so your 5 years residence has been acknowledged by the Home Office, you have your settled status. Those people can, if they want to, become eligible for British citizenship within 12 months of, after 12 months of having got that settled status. The person has to wait for 12 months following receipt of their settled status to become eligible. That is unless they are married to a British citizen, in which case they can apply for British citizenship immediately. Children born in the UK are not necessarily automatically British. Some are, but some aren't, and it's quite a complicated area of law, nationality law. So if you're in any doubt, please seek legal advice about that. But please don't ever assume that just because a child is born in the UK that they are always automatically British, because that's a trap that a lot of people fall into, and it can be difficult to unpick. The criteria for becoming a British citizen is centred around the length of time that that person's been free of immigration control, in this case settled status, whether they're married to a British citizen themselves or in a civil partnership. There are rules around absences, English language, and life in the UK, and knowledge of life in the UK. It's holding British citizenship is something that you should check with your home nation or any other nationality that you hold, whether it's possible to hold dual or multiple nationalities, because some countries don't allow that. And it would mean, by becoming British, it would mean having to relinquish another nationality that you already hold. So always best to start off by checking with the relevant embassies as to whether it is possible to hold that nationality as well as British citizenship. And becoming British, if it's not an automatic acquisition, it is an expensive process. Home Office application fees are between £1,000 and £1,300, depending on whether the child is an applicant or not. And the applicant is a child or an adult, and can also come with other associated test-related fees. And there's also a fee to attend a citizenship ceremony as the final step of your process of becoming naturalised as a British citizen. But more information is available at that website. So we've come to the end of the presentation, and I just wanted to draw your attention to the fact that International Student Support Team at the university are a great first step if you have any queries about the EU settlement scheme. As Christina mentioned at the beginning of the session, there's some information on the Cardiff University intranet, so please make use of that. Newfields, the law firm that I work for, is working with the Welsh Government to promote the scheme and to support the applicants that need to apply, which is part of the reason why we're delivering this session today. The advice and support that we provide is free of charge. And we specialise in assisting individuals with more complex backgrounds and cases, but we do help anybody who wants any guidance or assistance in making an application to the scheme. But just to reiterate that for the vast majority of people, it is quite a straightforward and quick process. So hopefully the materials in the slides today will help you with that, but please do feel free to get in touch with us if you come up against any problems that International Student Support can't help with. And these are our contact details. Okay, so I can see one question in the Q&A. I haven't looked at it yet.
Okay,
so,
are you going to answer the questions live, Abby? Are you happy to do that?
yeah, I'm happy to do that. I won't say who's asked them. I don't know whether this is public or not, but I'll just read the scenario if that's okay, because it makes sense then to everyone else listening. I had residence in the UK for about 6 continuous months. I left because of COVID in March 2020 and haven't returned since. So I've already exceeded the 12 continuous months absence. I'll return to the UK beginning of autumn semester, if the situation allows, in September 2021. I'm finishing my studies June 2022, and I'm not hoping to get settled status since I don't plan to stay in the UK after graduating. Can I still apply to pre-settled status, or do I need to apply for a visa? So if you already held pre-settled status, so had already made an application prior to 31st of December, then you can be outside the UK for up to 2 years and you'd still retain that pre-settled status. You just wouldn't ever have the opportunity to convert to settled. But if that's not an issue for you, then carry on, use your pre-settled status for its 5-year validity, maintaining no more than 2 years absence, and you'd be fine to come back and complete the end of your course. But what I think is the question here is that this person hasn't actually applied for a status, in which case, unfortunately, unless you have a family member here who was here by the end of December and could apply as a joining family member, then I believe that you would have to go down the visa route now in order to return in September 2021, having been outside the UK since March 2020. So I would direct you to international student support for some guidance on that. Make sure you get in touch with them sort of as soon as you can, so that you're nice and well prepared then for when you come back in the autumn.
We'll provide our email contact in the chat, just so everybody has it. You can always find our information on the intranet to get in touch with us. And of course, yeah, we do help with student visas, so do get in touch with us for help with that.
And I can see you answered the other question in the chat box, Christina.
Yeah, so just a brief one